Well, welcome to everybody who has joined us to our first family law brunch of 2024. Today, His Honour Stephen Wildblood, KC, and myself, Nathalie Bull, will be explaining arbitration in children and finance cases. Please do post any questions to us via the Q&A box that you should see on your screen, and we'll try our best to answer any questions at the end of the seminar. Our slides will be sent to everybody who has registered after the event, along with links to the resources that we will be referring you to. So I wish to open the seminar by setting out three perhaps all too familiar scenarios to you. The first is that the court informs the parties the working day before the hearing that the hearing has to be vacated due to judicial unavailability. The hearing will be relisted in 4 to 6 months' time. Counsel's brief fee has already been incurred. The second scenario is you arrive at court for a hearing to find only a legal advisor, no justices. The legal advisor cannot determine the issues. The matter, therefore, has to be adjourned and will be relisted in 4 to 6 months' time. Counsel's brief fee has been incurred. The third scenario is you arrive at court for a full day's final hearing to find a packed list, and you're told that unless the parties agree the majority of the issues or agree to proceeding on a submissions-only basis, the matter will have to be adjourned and relisted in 4 to 6 months' time. You're often left with the ultimatum of either striking out your intended timeframes and confining your list of issues to the bare minimum, potentially resulting in an unhappy client who feels as though they've not been heard, or adjourning the case off for months when the matter needs to be determined now. The client will incur a further brief fee and further solicitor's costs, which the client can ill afford. These scenarios cause the parties stress, anxiety, anger perhaps, and frustration. In children cases, the delay could cause lasting damage on the relationship between one parent and the child. In finance cases, there could be a significant knock-on effect of delaying financial resolution. As far as the parties are concerned, this service is simply not good enough. The courts and the judiciary are urging practitioners to keep cases out of court wherever possible. This would then lighten the court's load and enable the system to run more smoothly. We all need to do our part to work together to create an effective route to resolve disputes out of court. So we're here today to explain what role arbitration in children and finance cases has in lightening the court's load and in providing clients with a better quality of service. On that note, I'm delighted to now introduce His Honour Stephen Wildblood, KC, who needs no introduction, having been the DFJ for Bristol and the surrounding counties from 2013 until recently. We're thrilled that Stephen has recently joined the 3PB family team as an associate member of Chambers. Over to you, Stephen.
Well, thank you and good morning to everyone, and thank you for joining this seminar. We're going to cover 5 separate topics. The first is how are the courts managing, and I'm going to look at some of the statistics and the consequences of the workload that is falling on the courts. Second, why choose arbitration? And Nathalie and I will both speak on that point. Thirdly, whether arbitration is suitable for all cases of financial remedy and private law proceedings. Fourthly, what is the arbitration procedure? How does it work? And Nathalie has very kindly agreed to take that subject. And fifthly, Nathalie will cover what these chambers 3PB can offer. Before I go on to the first point, I would, however, like to take this opportunity publicly to thank these chambers for the incredible welcome that I have had and the efficiency with which this has all been set up for me personally. I have received most incredible support and kindness, and I do want to thank you very much for that. It's made a huge difference to me. Thank you. So I'd like to move on, please, to the first slide, and Nathalie has very kindly agreed to put the slides up for everyone to see. I spent some time looking on the internet for the statistics about how the family court is coping. And there you have the statistics. Firstly, about financial remedy applications. Applications up by 20% in the quarter from April to June 2023, compared with the previous year. I found that really surprising. Although disposal events, and that means how many cases are dealt with, were also up by 15%, it still means there is an incredible workload that is coming into the court in that area of work. And you can see it in the figures. 11,040 applications in the 2023 quarter. Compare that with the position in 2014, 8,775 applications, an increase of over 2,200. In relation to private law, applications have in fact gone down very slightly, but look at how long they're taking. When we talk about averages, what that means is that the duration of the proceedings is all added up and divided by the number of proceedings. So it is a mean average. And so the figures include those cases where people start and the case settles at the FHDRA or at a very early point. But the national statistics are that the average time for private law proceedings is 47 weeks. In 2020, so at the start of the pandemic, 30 weeks. In 2016, 22 weeks. And it may interest you to see the next figures. The number of cases where both parties had legal representation, 41% in 2013, and we all know what happened then, and 19% in June 2023. So we are obviously blessed with lots of people who can behave like Perry Mason, even though they have absolutely no legal training. Legal representation does make a difference. Can I just get that in? And you'll see there the figures about the comparative number of applications between 2023 and 2014. So the increase over that period was 3,206. The reduction of 4% relates to the period of April to June 2022 to April to June 2023. So overall, in the past 10 years, there has been a huge increase in the amount of work that is coming into the family court to deal with private law. Could we look at the next slide, please? Thank you, Nathalie. I'm only going to run through these very quickly because you can see what they are. DADV applications slightly increased, adoption applications up slightly. DOLS, deprivation of liberty applications, I hear loads of those when I sit, as I still do in the family in the High Court. There's been a massive increase in that over the past few years. When I was sitting full time, would sometimes hear 3 in a day, dotted in during periods of adjournment from the main case. And public law, the number of applications are down, but down from there having been a huge increase in the number of public law applications. And you will all know the dominance that public law therefore has within the court list and the knock-on effect that has for you when you want your private law or financial remedy cases to be heard. Thanks, Nathalie. So this is what the President said before the pandemic, that we were running flat out up a down escalator, that the court is being forced to work at well over its capacity And lawyers, that's you, are facing unremitting pressure due to the volume of cases reaching court. You know what that's like. I'm married to a family law solicitor, and that's our lived experience. I know the pressures that there are, and they are immense. Thanks, Nathalie. And this is what the president of the Law Society has said. Again, I won't read it out. Say for the third bullet point, HM Courts and Tribunal Services has previously estimated that it may take 3 years to return to pre-pandemic levels, which is very worrying. Well, think back to what you've just seen from the president about how things were in 2019 when he was saying that we are operating at extreme levels of pressure. And there the president of the Law Society is saying it's going to take 3 years, that's to 2025, before things will return to that crisis level. Thank you, Nathalie. What is the effect of that? Well, you know it because you live it. First of all, as Nathalie has said, cases being removed in the lists. And it only takes a move from a 10 o'clock to a 2 o'clock listing to really throw your work. My wife will book counsel for 10 o'clock. The case is moved to 2 o'clock. Counsel has another brief in another court. What do you do then? You have commitments as well. And moving cases within lists may well be necessary, or is necessary from the point of view of the court, but it can cause havoc for lawyers and clients together. 50% plus of private law cases currently are being heard by the magistrates. I believe very firmly in the magistrate court system. They have a considerable civic responsibility, but views I know differ in relation to that. If a case does go, it's relisted at the court's convenience. It has to be. And it is relisted in lists that are already filled up months ahead. My lists were full for about 5 or 6 months ahead when I was sitting full time. And that leads to delay, and delay is the enemy of justice. The effect of it also is to increase costs because cases continue for longer and the rolling stone gathers moss of expense and issues accumulate. Whilst people who have separated have not had a resolution of their issues, they're going to increase. In private law, we all know the rows that happen over interim contact. And in financial remedy work, the real strain that exists on finances when they are not resolved timelessly. So costs accumulate, and they do accumulate. And I want to give 2 extreme examples that I had. One, where the issue was, and I'm going to use old money language, the quantum of contact and the legal costs between people who were rich but not super rich were over £1 million to sort out the quantum of contact. Another example where I'm going to alter the figures to make sure the case isn't identifiable, where the issues were the quantum of contact and where the children should go to school. The mother's cost allowance created in Schedule 1 proceedings was a lump sum of over £150,000 and a monthly cost allowance of over £15,000. How can that happen in relation to issues of that nature? Thank you, Nathalie. Carrying on, the family cannot move on, decisions have not been made, and the children are affected. Cases get crammed into the list for short estimates, and you'll know what I mean about that. Judges change, and judges have limited reading time, and the whole system is vulnerable to burnout. One of the other things that causes specialist practitioners particular distress and dissatisfaction is that they have specialism. Financial remedy practitioners specialize in that field, and some find their cases being decided by people who do not share that degree of specialism. And I know the irritation that causes. And strain on lawyers, I don't think I need to say anything about that because you know it. Thanks, Nathalie. Could we look at the next one? So why choose arbitration? And Nathalie, this is where you and I join in together. So I think there is an idea that you just pay for the C100, £232, and you're in it for good. But where people are represented, it just doesn't work that way, is my view. Nathalie, I don't know what you think about the advantages of costs in relation to arbitration over court.
Yeah, thanks, Stephen. Well, although the parties will meet the arbitrator's fee, it's a streamlined service, efficient and speedier, and therefore, because you're avoiding delays, risks of adjournment and lack of judicial availability, lack of court time, it reduces the number of hearings and naturally, therefore, reduces the overall cost.
And the point that is made there about the speed of the process, I think that's such an important point, isn't it? Because you select an arbitrator and you can set the timetable by which things are going to be resolved. And so that leads, and I know this is the point that you contributed to one of the points that you contributed to the slides, higher quality of service. Do you think that's right?
Absolutely. And it's not only the process itself, but it's the pre-process. For example, not having to undergo the compulsory MIAM mediation information and assessment meeting. So you can start the process more quickly. And the higher quality of service, the clients don't feel rushed or shoehorned from a one-day trial into a 1-hour slot due to lack of court time. They feel heard through the process. And they will see from the written judgment the care and attention that the arbitrator has given to forming the decision.
And the next point we've mentioned is that you have a chosen arbitrator. So the parties, the solicitors, can consider their case. What do they need by way of an arbitrator, and they can select the person they together think is best suited to resolve the case. And that is a clear distinguishing feature between arbitration and court work. But also, I think it's right, Nathalie, isn't it? You can choose your expert. In court work, you are, in some cases, you get a CAFCAS officer, not always. But if you think in an arbitration that you need a welfare expert, you can agree that that is done, and you can select the expert. And I don't know what you think, Nathalie. I think that is a particular advantage over arbitration.
Absolutely. I agree, Stephen. And we've seen this time and time again when both parties or one party wishes to have wishes and feelings of the children, seeks a Section 7 report, but CAFCAS say there's no further role for CAFCAS because there's no relevant safeguarding concerns. If an application is made for an ISW, the court often finds that that's not necessary and therefore proceeds to final hearing without a report, without knowing the wishes and feelings of the children.
And also in this area, I know CAFCAS Section 7 reports are taking 18 weeks. And so the gap between an FHDRA and a DRA in a children case is going to, where there is a report, is going to be 18 weeks plus, the plus being that there has to be time after the report is filed for people to consider it. And so control of procedure, I mean, that's important too, isn't it?
Absolutely. The parties in arbitration really own the procedure to a far greater extent than is possible within court proceedings. They can tailor the process to their own needs, including whether the process is document only, conducted remotely or face-to-face. And the arbitrator has the widest discretion possible to adopt the procedures that suit the circumstances of the case.
Yeah. And the next point on the slide is one that is very dear to my heart, and that is judicial reading time and judgment writing time. As a full-time judge, I was working for at least 65 hours a week. It was unremitting. And I would often have for 5 cases in the list to read up the night before. You could not read them other than the night before because each day is full, and there is a constant feeling of not having read sufficiently for the hearing. In an arbitration, the expectation is that the arbitrator will set aside time to read the case properly in advance, and that is part of the service that is paid for. And I very much welcome the opportunity to work with that being in place, that I will be able to set aside a proper day to read, for instance, a financial remedy or a private law case, so that I am confident that I know what the case is about. And I think that is a very important feature of this. And also judgment writing time. I'm sitting next week and I've seen that after a 3-day case, closing submissions in the morning, judgment in the afternoon. I like time to think, and I need time to think to get it right. And I want to be able to go away, sit down at my computer and put together a judgment. In reality, it is only at that stage that I put the case together and form a concluded view. Otherwise, I'm engaging in what is called confirmation bias. You take a view on a reading of the papers and you just stick to it, and that's wrong. It's unfair. So having proper judgment writing time or determination writing time is a huge advantage within the system. And you then get a proper written, as I've called it, judgment or arbitration determination. Thank you. The next point is chosen venue. I mean, that's quite important too, isn't it, Nathalie?
Indeed, yes. You're not confined to a courtroom or waiting area. The parties are at liberty to agree where the arbitration takes place. If a 3PB arbitrator is chosen, then the option is the 3PB centres, which I'll go into later on in the seminar. There's also the IFLA office in London, the solicitors' offices, conference centres or hotels.
And it avoids the pressure on the court estate. And again, everyone here will know what it's like when you go to the court and you can't find a conference room, or that you are having to sit in the waiting area waiting for your case to be called, and that can be really awkward. Chosen date and time, I think we probably covered that. Confidentiality, that is a big point, isn't it?
Yeah, indeed. There's no possibility of the judgment being published or of journalists reporting, and for some parties that's very important. Yeah,
and that applies to both aspects of work, doesn't it? Private law and also financial remedy proceedings. And the next point is certainty. Everyone knows what the procedure is, and everyone knows how their case is going to be decided. Why? Because the arbitration process is based on the working together in an agreed procedure. The next point is something that's developed, isn't it, Nathalie? The point about, we've said you can appeal. It isn't strictly an appeal, but if there is an arbitration decision and someone wishes to challenge it formally, then they can do so by bringing an application to the court. And we put the case law in relation to that. Haley, and Haley is the Court of Appeal, and in relation to financial remedy cases, G&G, decision of Mr. Justice Peel. That might send a message of concern to some. I don't think it should. Appeals, even in the court system, are extremely rare. But I think it is important for people to know that if they did engage in arbitration and felt it had gone wrong, and things can go wrong in any system, that they have a means of challenging the decision in that way. The court applies the same test as it would on an appeal, and it is likely that any application to the court in the form of an appeal from an arbitration decision would be heard at circuit judge level rather than district judge level, I think. But there is that facility. And the next 2 points, better service to clients. Imagine it was your family. That comes from me, I added that bit, because I happen to think that the right way to view life is there's no such thing as them, there's only us. And it could be a member of my family, a friend of mine, going through this procedure. How would I feel about them getting stuck in contested litigation that went on for months and months in the way that some court cases do? And we both added the last one, didn't we, Nathalie?
Yes, I think we can both see the advantage of avoiding the portal.
Yeah. Some people love the portal. I wish them luck. But the financial remedy portal in particular, I think is known to have a certain degree of challenges, and some people might well feel there was a positive advantage of getting a system, a procedure that did not involve that. So those are some of the advantages of arbitration as we see it. And this one's down to me. Can arbitration replace the court system? Of course not. No, it's not an answer for everything. There are going to be cases where there is domestic abuse, injunctions, repeated or serious non-disclosure, where you're going to want penal notices added, and you're going to want to have enforcement of that nature. And although there are steps that can be taken through arbitration, most of those cases will be more suited to the court. And also where parties don't agree to arbitrate for whatever reason they say. One of the points that has been raised in question is what about the cost of the arbitration? Are we really trying to set up the equivalent of a private hospital system versus the NHS? Is that what we're doing, pandering to the rich and leaving those who are not wealthy to go through the court? No, we're not, and I would not engage in anything of that nature. We have a responsibility to provide a service to the community, and if this is a better service, then we ought to be able to provide it to all those who need it. And that is why, certainly in these chambers, there is going to be an arrangement for a sliding scale, of course, fees, and you would speak to the clerks to sort that out. But please don't think that you should be deterred from arbitration because your clients could not afford it. There would be a sensible arrangement in relation to it. And I've added those words, piloted. If you are not sure, try it. Speak to the clerks here. They're keen to get this started. It needs a good kickstart in this area. It's only slowly, taking off slowly, whereas it has obvious advantages. So speak to the clerks and set up an arrangement whereby we pilot it and you see where it goes. Okay, thank you. So over to you, Nathalie. Thank you very much indeed for doing these slides.
Thank you, Stephen. Just looking at the difference between arbitration and mediation, some question what the difference is. So in mediation, that is where parties are helped to come to an agreement and they decide between themselves the outcome. Whereas in arbitration, the arbitrator decides the dispute. The parties agree in the formal arbitration agreement that the decision will be binding upon them. It's already been said actually by Stephen, but the judiciary have made it clear that not only will the courts approve if the arbitration awards, they will also uphold them. And it's the case of Haley, and Haley Court of Appeal confirmed that arbitration awards are subject to the same test in relation to appeal as judgment of the court. So in arbitration at children scheme disputes, the scheme can be used for the disputes listed here on this slide, quickly going through them: where and with whom the children shall live, the spend time arrangements for the parents, arrangements concerning the children's upbringing, relocation of the children not only within England and Wales, but also international relocation to Hague Convention countries, and also specific issues such as change of schools, which can be a real knotty area, and also change of name. It should be noted that in children arbitrations, the parties will need to confirm and the arbitrator will need to be assured that there are no safeguarding issues which may require the intervention of statutory authorities in the dispute. Arbitration in finance disputes, I've listed on this slide and the next slide the cases that are appropriate. It would have been shorter to say what's not appropriate. Essentially, generally speaking, arbitration is suitable for virtually all financial cases. I'll just quickly go through those two slides, go past those. So, forms of agreement. The parties' agreement to arbitrate is via form ARB 1FS in the case of financial disputes, or form ARB 1CS in the case of children disputes. The form is to be signed by both parties, in which they describe and define the scope of the dispute they agree to arbitrate. The links to both forms will be sent to all of you after the seminar, along with our slides. In their forms, the parties expressly agree to be bound by the family arbitrator's written decision, subject to any right of appeal. The parties also expressly declare and agree that they've read and will abide by the rules, and that they understand their obligation to comply with the decisions, directions, and orders of the arbitrator. And when required to do so, they will make full and complete disclosure relating to financial circumstances. And in children arbitration, they will make full and complete disclosure in relation to any safeguarding concerns. In their forms, the parties can nominate a family arbitrator, but if they can't agree, then the parties or representatives agree that IFLA will choose a suitable arbitrator on their behalf. The form will be submitted to the IFLA administrator on the email address provided in this slide. The arbitrator then contacts both parties, seeking their agreement to the terms of appointment. On agreement of the terms of appointment, the arbitrator sends the parties a formal letter of acceptance, from which point the arbitration is deemed to have commenced. There will be consistency as the arbitrator deals with the dispute from start to finish. Looking at procedure, the Arbitration Act 1996 contains both mandatory and non-mandatory provisions. Mandatory provisions are set out in Schedule 1 of the Act. They are fundamental and immutable provisions which the parties may not agree to exclude, replace, or modify. The non-mandatory provisions may be modified or excluded by agreement of the parties. The arbitration rules make it clear that the dispute must be determined under the law of England and Wales. Subject to the mandatory requirements of the Act, as we said earlier, the parties really own the procedure to a far greater extent than is possible in court proceedings. They can tailor the process to suit their own needs, including, as we said before, whether it's going to be document only, remote, or face-to-face. During the course of the arbitration, any procedural decisions will be taken by the arbitrator after consultation with both parties. The arbitrator has a wide discretion to adopt the procedure to suit the circumstances of the case. The general procedure will usually involve a case management conference, either by telephone or video or in person, and often with only the representatives and the arbitrator, not the parties. At the case management conference, the question of experts will be considered. In finance cases, that might be a pension actuary. In children cases, an independent social worker may be required to explore wishes and feelings of the children. The logistics of the final meeting or final hearing will be decided at the CMC, including the date and time. And there's also flexibility of time, not just the court hours, but any hours that would suit the parties. The timetable will be considered, and it's common to agree that the final hearing will only involve the hearing of evidence to reduce the time of the hearing and reduce the costs of the parties. It would therefore be agreed that there would be written submissions after the hearing day. The family arbitrator's decision must be committed to writing and delivered promptly. The decision will include written reasons and a formal award. The decision is binding on the parties. In finance cases, the parties should always seek to convert the award into a court order by way of a consent order. In children cases, the parties can ask the court to convert a consent order into a formal court order, but the Red Book guidance is that applying Section 1, subsection 5 of the Children Act, the no order principle, not every agreement concerning a child requires the order to be converted into a court order. Stephen, I don't know whether you wanted to comment on that aspect.
Yeah, I can see that where there is a financial remedy arbitration, that there has to be an order that follows. I don't think that that procedure will be anything like as lengthy as court proceedings would be. You would in effect have a consent arrangement that you were converting into a consent order. In relation to children, then if an arbitration has been concluded and a decision is made and nobody seeks to, what we're calling, appeal it to the court, then I think in many circumstances there will be no need to obtain an order. The circumstances in which you might want an order would be where you think that there will have to be enforcement. But I can imagine that if parties go to a court with an arbitration determination in place and say, we agree this determination, we simply want an order to reflect it. What is the point, and why under Section 1.5 is it better for the children to have an order than for there to be no order when everything is agreed? So I can anticipate that many people in children, in a children case, will say, well, we don't actually need an order. And I don't think there's any way in which they can be forced to go to court, because at the end of the arbitration process, they get the determination. And who is going to tell them that they must go to court if they don't want to? So I think the position is different as between private law and financial remedy proceedings. I don't know, what do you think, Nathalie?
Well, I think that's a very helpful synopsis there, Stephen. Thank you. Right. On this side, there's a flowchart that's on the IFLA website. Thought this might be quite handy as a visual aid to look at the steps required. Really, it's the steps that I've taken you through, but in visual blocks. So you have the signing of the form, the family arbitrator being nominated, and the appointment of the arbitrator, moving on to the decision about case management, and the steps taken to look at the further meeting, followed by the award. makes it look quite straightforward, which it is. Now, the family arbitrators that we have at 3PB, or those awaiting qualification, include Stephen, who is awaiting his qualification in the children's scheme, which is imminent, as he's already taken the course, and he's due to attend the finance scheme course in September this year. We have Simon Lillington, year of call 1981, who's qualified in the finance scheme. Myself, year of call 2004, I did the same course as Stephen, the children course, and we are awaiting that qualification imminently. Carrie Mason, year of call 2004, she's due to do the children course in March of this year. And Amy Fox, who has qualified in the finance scheme, year of call 2007. So between us, we have from 17 to 44 years experience, and we all specialise in either both finance and children disputes. The course that we have all taken or are about to take is the IFLA course. Right, now moving on to the next slide, we have potential arbitration venues if a 3PB arbitrator is chosen. 5 out of our 6 centres offer sufficient facilities for arbitration, namely at least 3 conference rooms, which includes London, Birmingham, Bristol, Bournemouth and Winchester. Out of those, all but London offer disabled access. There will be optional catering for lunch that can also be provided. By way of an example, our Bristol facilities, we have modern purpose-built conference rooms, soundproof pods and comfortable communal spaces. In Birmingham, just some examples of the conference rooms available and the large communal space. Stephen and I have our contact details here, and we are happy to be contacted to answer any general queries that you have in relation to arbitration generally. Do feel free to contact us. It's now time for questions. So, Stephen, I don't know whether you have a question that you're going to be answering.
Well, there's questions that are coming under a number of different headings. Can I deal with one, because it's really rather dear to my heart? And one of the questions is this essentially privatising the court process? Is there a moral issue here? Isn't it also letting the government off the hook to some extent in easing demand and therefore justifying decreased funding? But that's certainly not why I'm doing this. I understand the point. I hope I've addressed it already. I think this has to be a service that is offered not just, as I've said, to the rich and possibly famous, but it has to be offered across the board. And that is why we have discussed this here and have that has led to the recognition there must be a sliding scale of expenses. And I think that's really important. I accept there is a moral issue here, and I hope I've addressed that. As I've said, I have a firm belief and indeed faith that has at its heart that there's no such thing as them in this world. There is only us, and we should treat people as we wish to be treated ourselves. And I hope that I show that in what I do. So I think it's a really good point. And no, I am not being involved in the system that is the equivalent of a private hospital system that caters only for the rich. I just think that would be completely the wrong message to send out. So thank you for raising that point. It's a really good one. And I know how much family lawyers are committed to providing a proper service to their clients. That's what you want, and that's what clients want. And the reason why I'm involved in this, and I think that others are involved in this, is not because they want to set up the equivalent of a private hospital scheme, but they, like me, genuinely believe that this will provide a better and cheaper service for clients than going into the court process in most instances. That's why I'm doing it. I hope that answers the point. Natalie, I don't know if you want to say anything about that, please.
Thank you, Stephen. I've just been looking at some of the questions whilst you've been answering that, so thank you for your answer there. I have one question. How much impact do the views of children have on the arbitration process, and how would their views be obtained if they are considered? We touched on this during the seminar. Essentially, the views of children are important and can be well catered for via the independent social worker route. If the parties don't agree on an ISW, under Rule 8.2.4 of the arbitration rules in the children's scheme, the arbitrator has the parties' consent by way of the form that they sign in the beginning to say that they have read and agreed the rules. The arbitrator can appoint an expert, ISW, to ascertain the wishes and feelings of the child or to advise on welfare issues if the arbitrator considers that such evidence will assist in determining the issues. And that's whether the parties agree or not. The cost of the expert will have to be met by the parties, but it is going to be of great assistance to have the wishes and feelings of the children. When comparing that to the court process, I think I've touched on earlier, often you don't have any sort of report going to a final hearing, and it's very difficult then to make a decision without knowing what the wishes and feelings of the children are. So I hope that answers that question. Stephen, is there another question that you would like to answer?
There are a lot of questions, as we anticipate, where people are asking, okay, so that's all fine. Bottom line, what's it going to cost? And there are quite a lot of questions that people have posted in relation to that. I think the answer to that, and it's not in my gift to give specific figures, but the answer to that is a reasonable amount that people can afford. And because there's no point in offering an arbitration service if people can't afford it. And what people can sensibly afford would have to be a matter of discussion between the solicitors and with the clerks. But what I am quite certain is the clerks here, and I'm sure this applies generally, would not leave people in a position where they were unable to afford the service that we want to establish. And I hope that doesn't sound Delphic, but I'm sure that people understand I can't give a pound, shillings and pence answer to that. So the answer is that arbitrators expect to be paid, as anyone does, sensible amounts that are reasonable and that reflect the circumstances of the parties. So, for instance, you've got two teachers, let's say on a gross pay of £35,000 each, £70,000 household income with two children and a mortgage. If an arbitrator is going to offer a service to them, it's going to have to be of a sensible amount that reflects their circumstances. And you as the solicitors, if they are your clients, are going to be very knowledgeable about what they can and cannot afford. And you will know the clerks well enough to be able to discuss it with them and agree something sensible. Natalie, I hope that doesn't sound too Delphic. I'm sure people will tell me on the question and answers if it is. And I don't think it would be right, would it, to go further than that, because it would be giving an unrealistic answer to a question that has to be case specific.
Indeed. Our clerks are ready and waiting to discuss with you fees, depending on the circumstances of the case, etc. So they are there to have these discussions with, and please do so. One question is, can arbitration be used after court proceedings have commenced? They absolutely can. And in children cases, if there has already been a safeguarding letter, that should be sent to the arbitrator, and that can often help. Stephen, I don't know whether you want to add to that.
No, I think that's absolutely fine. Thank you. One of the other questions people are asking, Nathalie, is what are the pros and cons of the private FDRs against arbitration? And I think the answer to that is that the arbitration is the whole procedure. In other words, if you're going to put your case into your financial remedy case into the arbitration process, then that deals with the whole application, directions, experts, and a determination from the court, from the arbitrator in the form of a final decision, whereas the private FDR is in a more confined context. Private FDRs make obvious sense, in my opinion, where there are proceedings and people can afford them because of all the difficulties that we've already discussed in relation to arbitration. But I think private FDRs take place in a different context and are focused on a different stage of the proceedings. Nathalie, I don't know if you have any views on that.
No, thank you, Stephen. That was helpful. There are so many questions. Thank you so much to everybody for
wonderful, aren't they?
all of your questions and engagement in this. I think we're seeing a lot of interest because it is fairly new in family law, and therefore it's a matter of trying it out, getting it up and running, and then hopefully it'll be a great success and be your port of call, I would hope. Stephen,
so one of the questions we got are orders made using arbitration enforceable on the parties? I think you've covered that. Yes, they are enforceable. They're enforceable through the court process. So if you've got an arbitration determination, you can bring that into the court process, and it is then enforceable through that process.
Yes, indeed. Yeah. Question about if solicitors have a good boardroom facilities, would arbitrators be willing to travel north? I think our chambers certainly are based nationally, and therefore we do intend to cover all areas of the country, not ruling out any particular parts of the country. So yes, travel is certainly an option.
One of the other questions, how keen are arbitrators to award costs in Children Act disputes? Generally, as with court procedures, the usual outcome in relation to children is that there should be, the parties will agree to bear the costs equally. But that again is a matter for that has to be dealt with on a case-by-case basis, and also as between the parties. If you have a mother, for instance, who has very little money, and the father has the greater financial resources, then that may be something that leads to a departure from that general provision. So it's very much like in the court. The approach to cost is very much like the court approach.
Stephen, one question is where there's a dispute about whether an ISW should be instructed. Is a Part 25 application needed before the case management hearing? Can the arbitrator direct shared costs for that expert? So no formal application is required. That's perhaps one of the benefits of arbitration. It would be a matter that would be discussed at the case management conference as to what is required leading up to the resolution of the dispute. If the arbitrator considers that an ISW is required, but the parties don't agree, the arbitrator can make that order, and the parties will be directed to share the costs of the expert.
And they can also make sure they get the right expert, and that's particularly important because there may be some cases where you may, for instance, want a psychologist rather than an independent social worker. And instead of getting an independent social worker or a CAFCAS officer you do in court plus a psychologist, you just get one expert. And that can be particularly helpful to people. And I'm noticing the time, Nathalie, it's 11:57. I think that means probably we have to express our gratitude to everyone. There are, to see the numbers, well, we've been up to well over 400 people, and people have given up their time to come and hear us speak, and I would like to express our gratitude to them. I'm really grateful to you for doing that, and I hope it's been helpful. But over to you, Nathalie. I think you're going to close the event here.
Thank you, Stephen. Apologies that we've not been able to answer all of your questions. We'll do our best after the event to get back to you with some answers. And as I said earlier, do feel free to contact Stephen or I with any general queries, which we'll do our best to answer. So thank you very much for joining us today at today's brunch. We do hope that that's helped to explain arbitration and has given you an interest in starting that process. The next brunch will be on Thursday, the 29th of February. Pre-registration link will be added to the chat box and emailed to you in due course. Hopefully you can join us then. There's also the 3PB second annual private law children and financial remedies national conference, which is on Thursday, the 25th of April of this year, and that will be at the Birmingham Repertory Theatre from 8:45 until 5 p.m. There's also half-day slots available. The full day will be worth 6 hours of CPD. The full price is £130 plus VAT for the full day, or for the half day, it's £80 plus VAT. We hope you can join us then. And that's all from us today. So thank you very much and have a good day. Goodbye.
Thank you.